Good day once again to the subscribers of Basic Philippine Law and Jurisprudence. We now continue on our lecture concerning the topics on persons and family relations law. The topic for today is separation of property of the spouses. Okay, Article 134 tells us that in the absence of an express declaration in the marriage settlements, the separation of property between the spouses during the marriage shall not take place except by judicial order. Such separation of property may either be voluntary or for sufficient cause. Now, you must remember at the outset that the difference between the regime of separation of property of the spouses and the other types of uh, property regimes during the marriage, such as absolute community or conjugal partnership, is that separation of property, okay, during the marriage cannot take place by just an agreement between the parties. It will take place only, or it will take effect only by judicial order. Okay? Before the marriage, there is no question that if you agree on a separation of property before you got married as your uh, property regime, then it can be done even without seeking prior judicial order. But once you already get married, okay, once you're already married, okay, and you want to transfer, for example, to a separation of property regime, okay, you can do so only through a judicial order. So it may be voluntary, which requires the joint filing of the spouses, or involuntary, which can be filed by either of the spouses, but there has to be a ground or a sufficient cause, which are provided under Article 135 of the Family Code, okay, which provides that any of the following shall be considered as sufficient cause for judicial separation of property. Okay, first, that the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. Okay, that the spouse of the petitioner has been judicially declared an absent. Okay, so what is the reason? Why is it that if one spouse has been sentenced to a penalty which carries with it civil interdiction involves, okay, the incapacity of that spouse to give consent to contracts. Okay, so if there is a need on the part of the spouse, the present spouse, to sell, to encumber a community or a conjugal property, then the spouse who is suffering from civil interdiction cannot give his or her consent. Okay, so it is a sufficient cause for the present spouse to seek a court declaration of judicial separation of property. The same reason with an absentee spouse. The absentee spouse cannot give his consent to any disposal or encumbrance of community property. The loss of parental authority of the spouse of the petitioner has been decreed by the court. Okay? That is another ground for seeking judicial separation of property. That the abandonment of one spouse by the other spouse, or failure to comply with his obligations to the family. Okay, that is also, if there is abandonment, then in effect, the present spouse cannot obtain the consent of the other spouse. So that is the reason why you can seek judicial separation of property. That the spouse granted the power of administration in the marriage settlement has abused that power. So if there is abuse of power of the administrator spouse, okay, that is also a ground for judicial separation of property. that at the time of the petition, the spouses have been separated in fact for at least 1 year, and reconciliation is highly improbable. Remember what we discussed when we were discussing the absolute community of property regime? The separation in fact of the spouses will not affect that property regime. So, however, the spouses may use it as a ground for seeking judicial separation of property. They have been already separated for at least 1 year, and that reconciliation is highly improbable. Okay, now the grounds provided under Article 135 for seeking judicial separation of property is exclusive. Okay, so if it is not provided, then it cannot be used as a ground for seeking judicial separation of property from the court. Okay, how do you seek judicial approval from the court of the regime of judicial separation of property? If it is voluntary, meaning you have no ground but both of the spouses want to transfer or shift to judicial separation of property, even without the existence of any of the grounds, you can do so under Article 136. The spouses may jointly file a verified petition with the court for the voluntary dissolution of the absolute community or the conjugal partnership of gains, and for the separation of their common properties. Now, the creditors will be notified once the separation of property has been decreed. The absolute community or the conjugal partnership of gains shall be liquidated in conformity with the code. After dissolution of the absolute community or the conjugal partnership, the provisions of complete separation of property shall apply. Remember that declaration by the court of a judicial separation of property is one of the grounds for the termination of the absolute community or the conjugal partnership of gains. Okay, now, how will the creditors be notified? The petition for separation of property and the final judgment shall be recorded in the local civil registries of property. Okay, the separation of property shall not prejudice the rights previously acquired by creditors. Okay. These spouses may, in the same proceeding where the separation of property was decreed, file a motion in court for a decree reviving the property regime that existed between them before the separation of property. So, if, for example, you were previously governed by absolute community or conjugal partnership before you shifted to a judicial separation of property, can you revert back to your previous property regime? Article 141 allows that. How do you do it? By filing a simple motion in the court where you filed your petition for judicial separation. Okay, a motion for revival of the previous property regime. However, any of the following grounds must exist. Okay, when the civil interdiction terminates, because once civil interdiction terminates, that spouse which was previously sentenced to suffer that accessory penalty of civil interdiction is now already capacitated to enter into contract. So the previous reason invoked for judicial separation of property no longer exists. Okay? When the absentee spouse reappears, the same reason, when the court being satisfied that the spouse granted the power of administration will not again abuse that power, authorizes the resumption of said administration. Okay, number 4, when the spouse who has left the conjugal home without a decree of legal separation resumes common life with the other spouse. And when parental authority is judicially restored. And number 6, when the spouses have been separated in fact for at least 1 year reconcile and resume common life together. And last, when after voluntary dissolution of the community property or conjugal partnership has been decreed upon the joint petition of the spouses, they agree to the revival of the former property regime. Okay, however, no voluntary separation of property may thereafter be granted. Because you must remember that there are two kinds, di ba, of judicial separation of property. One of which is voluntary, meaning there are no grounds for judicial separation, but that the spouses jointly, okay, agreed to shift from either absolute community or conjugal partnership to judicial separation of property. If they want to revive their old property regime, okay, the only thing that they have to do is file a joint petition for the revival of the previous property regime. But if after the motion for revival has been approved, okay, they can no longer, okay, shift to judicial separation of property voluntarily. But they can, one of them, if there is a ground which subsequently existed for the judicial separation of property, then they can do so, but only with respect to the instances when there exists a ground. Now, in cases of involuntary judicial separation of property, if the ground, therefore, no longer applies, then you can file a motion in court for the revival of your previous property regime. Okay? Article 142, the administration of all classes of exclusive property of either spouse may be transferred by the court to the other spouse when one spouse becomes the guardian of the other spouse, when one spouse is judicially declared an absentee, when one spouse is sentenced to a penalty carrying with it civil interdiction, and when one spouse becomes a fugitive from justice. Now, what is separation of property? Okay, it is that property regime which can be agreed upon in the marriage settlement, whereby each spouse shall own, dispose, possess, administer, and enjoy his own separate estate and earnings without the consent of the other spouse, with each spouse proportionately bearing the family expenses in proportion to their earnings and profits of their respective property. Okay? So in other words, in separation of property, there is no common property. To each his own. Okay? Meaning, the spouses, okay, have their own separate properties. Okay? The income from the said separate properties will also be their own. Okay? They will contribute to the expenses, like, for example, the household expenses, education of their children, and other expenses jointly and in proportion to their respective properties. So, meaning, considering that they have their own separate properties, the consent of both spouses is not needed for the disposal or encumbrance of their respective separate properties. Okay, we have the case of Soliano versus Soliano. It is a relatively new case, 2021. Jose and Rosario were married but have been living separately. So they are strange spouses. They begot 3 children. They signed a handwritten agreement denominated as dissolution of property and support with the assistance of a mediator. So, however, the petitioner failed to comply with the agreement. Now, the issue is, may the husband and wife validly enter into a compromise agreement dissolving their property regime. Okay, remember there are two kinds of judicial separation of property. First is the voluntary, which requires the joint filing in court and approval thereof by the spouses, okay? And the involuntary, which requires the existence of a ground for uh, dissolution of the present property regime and transfer to a judicial separation of property. Both of them, both these modes, whether voluntary or involuntary, they require court approval. Now, can you dispense with court approval and just enter into an agreement after you got married, okay, to dissolve either the absolute community or the conjugal partnership and transfer now to a regime of complete separation of property? The answer of the Supreme Court in the case of Soliano states that Article 134 of the Family Code states that the separation of property between the spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. The separation of property is not affected by the mere execution of a contract, but by the decree of the court approving the same. It therefore becomes effective only upon judicial approval, without which it is void. Article 192 of the said code provides that the conjugal partnership is dissolved only upon the issuance of a decree of separation of property. In voluntary dissolution of conjugal partnership, the spouses are required to file a verified petition before the court and notify both their conjugal and personal creditors of its filing. The voluntary dissolution of property regime by the parties perfected through a compromise agreement is void, where the parties failed to comply with the procedure set forth by the Family Code on voluntary dissolution of conjugal partnership. Remember that you can only enter into an agreement providing for the separation of property regime before you got married. After you get married, you cannot shift, modify, amend the property regime that you have agreed upon unless, okay, you are shifting to a separation of property through the approval of the court. Okay? You cannot just shift into any other kind of regime, okay, such as judicial separation of property without seeking judicial approval. Now, can you transfer from absolute community of property, okay, to conjugal partnership of kings after you have already got married? The answer is no. The only shift allowed by law is from absolute community or conjugal partnership to a regime of complete separation of property with prior judicial approval. Okay? We have the case of Noveras versus Noveras. Okay, David and Leticia were married December 1988. They resided in California, USA, where they eventually acquired American citizenship. During the marriage, they acquired several properties in the Philippines and in the US. However, sometime in 2003, David abandoned his family and lived with Estrelita in Aurora province. Upon learning that David had an extramarital affair, Leticia filed a petition for divorce with the Superior Court of California, which was granted. Later, Leticia filed a petition for judicial separation of their conjugal properties before the RTC of Baler, Aurora. Okay. Leticia anchored the filing of her petition on the ground that they have been separated, in fact, and reconciliation is improbable, which is one of the grounds for judicial separation of property for cause or with sufficient cause. Okay? The records are replete with evidence that Leticia and David had indeed separated for more than a year and that reconciliation is highly improbable. First, while actual abandonment had not been proven, it is undisputed that the spouses had been living separately since 2003 when David decided to go back to the Philippines to set up his own business. Second, Leticia heard from her friends that David was already cohabiting with Estrella. So the grant of judicial separation of the absolute community of property automatically terminates the absolute community of property regime because it once the court approves the judicial separation of property and there has already been liquidation, okay, then the judicial separation of property begins, okay, to take effect. Okay, so we have the case of Babano versus Executive Secretary. The issue in this case is whether or not the non-inclusion by the petitioner in her SALN, the Statement of Assets, Liabilities, and Net Worth of the vehicles owned by and registered in the name of her husband is correct or a neglect of duty or a mistake in good faith. Okay. In this case, petitioner and her husband were Muslims. So she was his second wife. Okay, now under the Code of Muslim Personal Laws, it defined the regime of property relations as one of complete separation of property. Each spouse fully exercises all acts of ownership and administration over his own exclusive property without any need for consent from the other spouse. So the exemption of the petitioner from the disclosure requirement should be clear and undisputed. As such, petitioner's non-disclosure in her SALN of the properties pertaining to her husband and held by her husband outside of her own household with him was not actionable. Each spouse in marriages covered by the regime of complete separation of property may exercise complete dominion over his exclusive estate. No permission or consent of one spouse before one spouse can exercise acts of ownership or administration may be uh, demanded. So in this case, if you're governed by complete separation of property, you need not declare the property of your spouse in your SALN because that is the exclusive or separate property of the other spouse. Under the regime of complete separation of property, each spouse may unilaterally acquire or dispose property without notifying the other spouse. A spouse cannot prevent or interfere with the ownership, disposal, possession, administration, and enjoyment of exclusive property by the other spouse, including all fruits and earnings arising therefrom. So that is all for separation of property. Thank you for listening.